seated. Good afternoon. Welcome to the First Court of Appeals. We have one case on the docket this afternoon. It is case number 01-23-00416 City of Houston versus Jose Alberto Corrales. And starting with the appellant, counsel, will you please make your announcements?
Robert HIGGASON for the City of Houston.
Andrew Parma for APPELLEE, Mr. Corrales, and this is the trial counsel here, Mr. Goff, Jason Goff.
Thank you. Each side will have 15 minutes for argument. Does appellant wish to reserve any time for rebuttal?
Yes, Your Honor, I would like to reserve 5 minutes, please.
5 minutes reserved. Thank you. Very good. Before we begin, you're probably already very familiar with this, our light procedure that tells you green means continue, yellow means you have 1 minute, red means stop. Unless you're in the middle of answering a question from the panel, you may continue. And also let me state, we obviously are familiar with the underlying facts, so you don't have to go through and recite them for us. If you want to just dive right in to the legal issues at hand, that would be most helpful. With that said, you are now we're now ready to proceed and hear from counsel for the appellant.
May it please the court, I'm Robert HIGGASON for the City of Houston here, and this is all about whether or not the trial court has jurisdiction to award costs of court and non-taxable, what would otherwise be non-taxable professional fees by an interpreter's fees who was not court appointed. And this might be a question of first impression as far as the specificity of the interpreter's fees. However, it is controlled by, or should be controlled by, 3 other cases, those being Gulf Coast Center v. Curry, that explains that the limitations on liability in the statute, in the TTCA, are intertwined with subject matter jurisdiction. It has a good analysis in there, and if something is not specifically stated as being recoverable in the TTCA, there's no jurisdiction to award it. Another case that leads to the result that we're asking for is Manbeck v. Austin ISD, and these are all in my opening brief, which says that where the TTCA, and this is from the Texas Supreme Court, where the TTCA is silent, there is no waiver. And in that case, it was about attorney's fees.
So quick question on that. Let's say that the statute said, had the substantive waiver of immunity without a corresponding limitation. So it didn't say you could recover damages. It didn't say anything about what you could recover. Is your position then that you could recover nothing?
I think we would be dealing with many cases that would find their way up to the Supreme Court to see how they would construe that waiver. That would be a very, very troublesome statute to say there's a waiver of immunity, and so then where do you go from there? But since it does have some limitations that are encompassed in it, that goes to immunity according to these Supreme Court holdings.
And when here we have the statute says damages, why couldn't damages include costs?
Because damages aren't costs.
Why?
They never have been costs. They're a separate line item. If you were to do that, then you could also make an argument, good argument, not a good argument, but an argument that might get through some courts that attorney's fees are costs. Are damages, right? Excuse me. That attorney's fees are damages because this is something that the plaintiff incurred one way or another. And that's not a good argument. I mean, we probably all would agree that's not a good argument. They've always been delineated, but so have damages and costs.
So to the extent that, because we're looking at, I suppose in this case, the property damage or personal injury type of case where the TTCA provides this waiver, not only to suit but also for liability, knowing that that the damages are going to be for someone's either loss or damage to property or personal injury, wouldn't the idea be to make that plaintiff whole? And wouldn't that include recouping their costs incurred in bringing their lawsuit?
Your Honor, that's a question for the legislature. It's a good argument, a nice argument, but it's solely within the legislature's hands. And the underlying policy is to not pay out everything that someone might need to be made whole. We can use the exact same argument, Your Honor, to say that there shouldn't even be immunity, that the plaintiff's not going to be made whole. And in fact, that's the reality of many situations where a plaintiff is injured and there is no recovery simply because of immunity. So we have to go back to the foundational principles, which are somewhat limited by the TTCA. And the Supreme Court has repeatedly held that any waiver has to be very strictly construed and has to be clear and unambiguous. And
but here the waiver, we're not fighting over the waiver. Everybody agrees there's a waiver. The question is the extent to which costs are included, right? The waiver is clear.
There was a waiver that got this case into court, and a prevailing judgment for the plaintiff. Yes, sure. But that waiver doesn't extend this far. If we read Gulf Coast Center, it talks about there is no subject matter jurisdiction for the trial court to award beyond what is expressly included in the waiver of immunity in the TTCA.
Is your position that that's just based on the language of the TTCA, or that applies in all immunity?
Well, that's about the TTCA, which gets us to one of the Mr. Corrales's arguments about a case that was not a TTCA case in RMH, and that was under the Family Code, and so it just really doesn't even apply to it at all. And there are some other instances. If you have a case that's not brought under the TTCA, there may be some other statute that has different waivers of immunity. We start off with immunity. This is the default position always. And so to get anything from any governmental entity level, whichever, state, or city, there has to be something that the legislature puts in there and says, okay, we're going to carve out part of the waiver, part of the immunity here, and waive it for this, under these situations, and then even this far, including these damages. It doesn't say anything about cost, doesn't say anything about attorney's fees.
What's your best example of another situation in which there's a waiver of immunity, but it doesn't extend to the full claim?
Oh, okay, sure. I think that Gulf Coast Center v. Curry, where it talks about the limits, you can't go above the cap on damages.
Right, but the limits are expressed in the statute. The statute here is silent on costs.
And if something is not expressly waived in there, you don't get it. I mean, this goes to the Texas Supreme Court's Mansfield v. Austin ISD that I was just talking about. No attorney's fees because it doesn't say you can get attorney's fees. And really, if you want to talk, Your Honor, about making a plaintiff whole, and I've done plaintiff's work before, and I understand and I appreciate all that. Now I'm doing defense work. And trying to protect the public funds, right? So it's a different perspective, but I'm looking at this from the standpoint of the legislature's waiver in the TTCA, exactly what they're saying, and then how the Supreme Court has interpreted that. And so if we are going to find a way for a plaintiff to get something that might make that plaintiff whole, or at least partly there, then we have to read this exactly, see exactly where the waiver is, the waiver of immunity is, and if it's not there, it's not there. As I mentioned before, if you could recover attorney's fees, the plaintiff would definitely be more whole, regardless of the arrangement between the plaintiff's counsel and the plaintiff. If the plaintiff didn't have to pay those attorney's fees, if you got $1 million, and half of that, or say even just a third of that, pittance these days, is the attorney's fees. Well, wouldn't it be much nicer making the plaintiff more whole if the plaintiff had all $1 million in damages and injuries?
Oh, and I'm not trying to quibble with you, but in that example, we're talking about, again, an area of law that doesn't already generally provide for attorney's fees, right? We're talking about torts here, right? The Texas Tort Claims Act. We're not talking about breach of contract
Sure.
or, you know, a declaratory judgment action, you know, something where otherwise there are statutorily provided attorney's fees. So here, and correct me if I'm wrong, it's been a while since I went to law school, but as I recall, you do not get attorney's fees for tort claims. Isn't that correct? Generally, under, I guess, the common law, you would say, case law?
Okay, that's true. Would you imagine how many claims there have been for attorney's fees in tort cases? But
Absent statute, if there's some statute out there, I'm sure there may be
Right.
some
Right, sure.
carved out, but for the most part,
Oh.
these are essentially, these are tort claims, right?
That's right.
Negligence type
That's right.
claims. You
You're
do not
right,
get
Your Honor.
attorney's
In my
fees.
best memory, and it was, and I think it's been longer for me than for you, perhaps, but that's my understanding as well.
So that, to me, that's a very different question and not necessarily the best analogy, and we are talking about a separate type of, I don't want to use the word cost because costs in and of themselves are a category. Here we're talking about, you know, costs and fees, but not attorney's fees, right?
Right. Now, they could have recovered the interpreter's fees had the, or apparently could have, had the interpreter been court appointed. And that was
Is that
not
the
case
city's
here.
position, that if
Yes.
the interpreter had been appointed by the court, then those fees would have been recoverable by the appellee here?
And why?
Rule 141 applies to court-appointed professional fees, and my time is up.
Thank you.
May it please the court. I would like, I mean, I am frustrated by this case because in reviewing the research for it, every time we talk about costs involving the Tort Claims Act or any of the other waiver of the sovereign immunity or government immunity cases, it gets tangled up with attorney's fees. And as I know, you know, and we all know, those are very strictly regulated by, if it's not in a statute or some other way to recover those fees, you just don't get them. That is not the true with costs. Costs are awarded as a matter of course. Costs are not damages. The costs don't count against the caps which were at issue in the Gulf Coast versus Curry case.
Let me stop you. You just said costs are not damages. So your position is not that costs could somehow qualify as damages?
I don't think that, no, I don't think they do. They are a reimbursement to the successful party for his trouble in prosecuting the suit. That is.
Then let me ask you a question about the statutory language. Doesn't 101.025A say that immunity is waived to the extent of liability created? Isn't that the language of this provision?
Well, that's 101.025, and this is going back to the idea that there's immunity from suit and then there's immunity from liability.
But this is linking them, right? Isn't that not just the case law that Mr. Higginson talked about, but isn't this provision of the statute saying that immunity is waived only to the extent of liability here?
I mean, I understand that the language you're talking about implies that, but I go back to Texas Department of Criminal Justice versus Herring, which is probably 1974 case, which is very early in this statute's run in the jurisprudence of the state, and they talk about, and that's where they come up with the notion that once you're in, you're treated like any other litigant. And they're talking the state of Texas. That was a Tort Claims Act case. That was also a tort case. That was an inmate litigation in which the inmate basically didn't. I mean, it's mostly remembered for the fact that we have, special exceptions which have to take precedence. But they also specifically say that you state once you're in as any other litigant, any private litigant. And ever since then, I mean, costs have been awarded as a matter of course in Texas Tort Claims Act cases, and I think the city's position would be to upset what I've seen to be a very settled area of the law.
What
That
can you,
was- oh, go ahead.
can you point us to something settled? Because it doesn't, I am not aware of something that's directly addresses this.
Well, it does. I do not believe that cost is used anywhere in the text of the Texas Tort Claims Act, which is why I keep going back to cases like Texas Tech University versus Lowe, which is about that same period, and they echo that same language. This is our understanding of the history and the intent. This is what we have in the case where we have a statute everyone agrees is not a well-written statute, that needs to be updated, it needs to be revised, but nobody can agree on how to revise it. And so we've been limping along with this statute for, what, 40 years or so? And so courts have been making do with it, but they start, I think, with that understanding.
How do you deal with Curry, Rattray, and Manbeck?
Rattray, as I recall, Rattray was a case in which they eventually found a waiver of sovereign or government immunity. They went through a lot of, this and that, and a lot of, talking about these. I think they had the example of the pool is open on weekends except, unless it's a Saturday or a Sunday when it's cold outside, and all these qualifications showing, and they were pointing out how badly written some parts of this statute are. And they said, it gives once you're in, but then you got to look at the ways they take you out. But all those examples, as I said in my brief, all those examples go to the initial calculus. Are you in? And that's my shorthand for is this a case which the court has jurisdiction over to determine the merits of the case? And if you're in the courts for that purposes, then the courts get to come forward, and then the courts get to handle all the business, of which costs is one part of that business. I mean, the act was never intended, it was intended to be a benefit to parties injured by government actions in these specific categories. And they were doing that to make it was more of a remedial approach, because before that you didn't have much redress. And so you have to look at it, I think, from that perspective.
Sure, and I'm just curious because it seems that, and neither side has pointed to us to, and we seem to not have found a case specifically dealing with this statute, these types of costs. And so I'm curious because you said earlier that these types of costs, and when you say these types of costs, are you talking about these particular interpreter, non-court appointed costs are awarded all the time in these types of cases, and it's just never been brought up on appeal? And I'm not asking you for, in your experience and your knowledge.
I will tell you, our firm litigates a lot of tort cases, some of which are against the government, and many of which involve Hispanic plaintiffs. And this is not something that has been, I mean, costs are awarded more or less as in a private litigant situation, and nobody has complained about that since I've been there, and that's only been 3 years, but my experience has been before is that this is not the area of costs, because it is that in-between category that is not damages. And it's also not attorney's fees, because that's the American rule, that's heavily regulated, it's got its own statutes. And just briefly, I'm not going to complicate the analysis any further than that. There is a case which I think may involve separating that immunity from suit and immunity from liability. And that was, I think, Davis versus City of San Antonio, which I don't cite in my brief, and I apologize for that. But that is a case which, after it was decided, and this is probably late 80s, in 1989, I think Justice Kilgarlin wrote it. And it was a similar factual pattern in that the city didn't object to certain, it may have been costs, it may have been an award of damages, but didn't do so until it filed a JNOV after trial. And that was where Judge Kilgarlin said, you waived that because this is an affirmative defense that has to be pled. And I'm a little bit on the thin ice because I don't know if any judge or lawyer who can really explain where that case sits in the pantheon. But they talk about the fact that you've got to give fair notice to the other side, just like any other, and they go into the same language, which is once the state is in, it's in. And they talk about if you had been a private litigant, you would have waived any objection here, and that's what we're going to hold here.
Let me ask you another question. Okay, so the premise of once you're in, it's in, makes sense, kind of this big picture, but not necessarily in line with what you see in these actual statutes. So would you agree with me that different statutes have different waivers? Sometimes they include costs, sometimes they include fees, sometimes they don't?
I agree with you.
So if that's correct, how could it be, if we're faithfully interpreting statutes, if sometimes they include these and sometimes they don't, how is that not a problem for the once it's in position?
I will put it this way. I'm concentrated because this is a Texas Tort Claims Act case. There are cases like the Commission of Human Rights Act statute, whistleblower statute. They've all got their own criteria, and some of them are more specific, most of them are more specific on what can be awarded. There's even a statute in the local government code that authorizes entities like the City of Houston to reimburse court costs and attorney's fees for any employee who gets, who has a judgment incurred against them, or incurs a judgment against them.
May I stop you there? Because there's something
Yeah.
that I had a question about in reading the briefs, about that, I guess, argument that you're making, or that analogy about the local government code, and only if you have, and obviously in this case you had the city, not the employee.
Sure.
But it made me think about the fact that here the only way the city acts is through people, right?
Yes.
And here you had a city employee who committed ostensibly a tort, and that's
Mm-hmm.
why
Right.
they were found liable.
Right.
So then, can you remind me, and I know this is outside of this, but I know in governmental immunity cases, isn't it the case that if you had sued the employee, then the city can have that employee dismissed, and then the city can take the defense? Is that an accurate very general statement of law?
It's an accurate generalization. I have actually had to deal with this statute in some detail.
So then in that case, so then I took it a step further and applying it here, and I don't know if this was actually, I don't know if this was part of our record. I don't think in this case your client sued the employee directly. Was it just against, or was it against the city from the beginning? Do you know?
Honestly, I cannot speak to that.
Okay.
I didn't go back that far.
Sure.
And
And it's not, I mean, you would think it's not relevant, but because of this, I was thinking about it and I thought, well, if the employee were found liable, costs would have been applied based on the local government code. But if the city can step in and have that employee dismissed and then be the defendant, is that kind of an end run around having to pay costs? It's just a question I had in looking at the briefs.
And I have to admit, this is an informed guess, because I have had to deal with that. Yeah, the statute you're talking about, it says if you sue just the employee, you can't sue the government. If you can't just sue the government, you can't sue the employee.
So it's when they're both sued, they can say
But when
dismiss
you-
the employee and just sue us as the city. In certain, I think it has to be within the scope, certain things that, again, is a very big generalization.
Well, sure. Mr. Higginson might disagree with this interpretation, but there is a section that says if you sue both of them, then the city can dismiss the employee, but by doing so, the city is admitting that we're the proper party, and we can't now say that you can't sue us because the employee was the right guy to sue. And so...
It's an admission, right, that they were within the scope.
Exactly,
all of
and
that.
that's 106.1, 101.106.
I know this wasn't part of this
or
case, but
something.
it's something that was puzzling to me when I thought about it and how that might be an interesting quandary here.
If I can bring it all together, because I digressed there, and that was my fault. But if you go, it's not a good fit between the statutes, and I don't know which one was first. I believe that the election and remedies provision was like a 2003 innovation with the House Bill 4 and all of that. But I don't know when that local government code section was enacted. But it is a recognition in any case that at one point the legislature considered that, yes, you could be held liable for costs because they specifically say you can indemnify your employee who gets hit with a judgment can be reimbursed for those costs. And costs have that, term of art kind of meaning about them.
I have one more quick question.
Yes.
You point us to 7 or maybe even more, I have 7 written down here, cases in your brief, but none of them are interpreting the Texas Tort Claims Act, right?
Well, I would say that the oldest cases, Texas Tech versus Lowe, and the Texas Department of Criminal Justice versus Herring are definitely Tort Claims Act cases. And these are like 1974, 75 kind of cases, which would be 5 years after the act was. And these are like the ones you have to look at if you're going forward about how the people who passed that statute intended it to be interpreted. And so that's why I rely on them. So I would say that...
But looking at Kierstad, Houchins, RMH, Reyna, Childs, Reed, and Strickland, you're not taking the position that any of those, you're saying those could be persuasive authority, but you're not saying that those either are binding or are on this statute.
Sadly, none of them were first court cases. But I think all of them can be distinguished at some point. But then you have to remember that if you're talking about jurisdiction to hear a claim, that's a broader topic than just the niceties of a particular statute, or it arguably is. And so I cite them as persuasive authority. And again,
Perfect.
I don't see a lot of cases out there that are that specifically on point with what we're talking about today.
Right.
I think that's probably because if you're going to trouble with for example, there is a case from the 14th involving the city of Pearland, came out 6 years ago, contract case. So I don't know if I cited it in the paper or not, but it was something that didn't. It fit on all fours as far as talking about jurisdiction and that sort of thing. But it was a contract case, and that's probably distinguishable on that basis. But when you're talking about the larger scope of the legislature's waiver of sovereign or governmental immunity, in cases like this, in which there's wrongdoing by the court, by the government unit, they are entitled to some, that they have something to say on the subject. And so that's why I cited them.
Yep, perfect, thank you.
Thank you.
Thank you. Your time is up. We appreciate your
Appreciate
argument.
it.
I'd like to respond to a question that you asked, Your Honor.
Thank you. I was going to ask you to. Thanks.
About that you were referring to the election of remedies provision. If if both are sued, and the suit could have been properly brought, just properly brought against the city, then there's provision for dismissing the employee. Okay, this is just kind of describing it generally. And that is, and you're asking, I believe you asked, does that constitute an admission by the city?
Well, isn't it, don't they have to within, and again, this is not this didn't happen, I don't think, in this case, and maybe it did, and it just wasn't brief because it didn't seem to be relevant. Now I feel like it might be, in the sense that I thought, okay, well, doesn't it have to be that the employee was acting within the scope? Doesn't they have to admit that part of it in order to dismiss the employee, or is that not part of it, and that's just me making it up?
I think this is something that the Supreme Court has not yet clearly decided. There are some intermediate appellate opinions that say that constitutes an admission by the city, some that don't, and that also wasn't relevant to me as I was preparing this, and so I didn't really prepare that for here now. But I can give you just a little bit of a suggestion of why it's not very much of an admission. A suit against the city, say there's no employee sued. They just sue the city. All right. We have certain kinds of well, I don't even have to call them defenses at first. To say we can file certain motions to dismiss, and say 91A is one that we frequently file, because that one you can say, all right, the facts as alleged do not show a waiver of immunity. All right, so just that. That alone can, if the court ultimately agrees with our analysis or assessment of the alleged facts, dismissal, regardless of anything that might have ever happened with an employee before that. And so even if you have a case where they sue both the city and the employee, and the suit could have been filed, that is, against the city, then under 91A, under the election of remedies, the employee has to be dismissed. But that doesn't mean the city is in either. So it can be that there just is not a remedy for this harmed person. Now that's something that we have to all kind of get straight in our minds, that sometimes somebody's hurt by the government and there is no remedy.
Yes, except in this case, there was a judgment finding the city liable. So yes, we understand that, there is immunity, and so that, but I would like to know what your response, and again, very impromptu, to that question about if you could have just sued the employee. And another question I had, and I don't know if maybe, I'll look at it later too, but the reimbursement of the employee's cost, if it's a judgment against the employee, a city employee, is that for the employee's costs, or that's costs that are awarded within a judgment?
I just don't know.
Okay, so maybe, but I'm just saying that's a little bit interesting to think, so if you just sue the employee, but you don't bring in the city to give the city the opportunity to have the employee dismissed, and you just get a judgment against the employee, and then the city can pay the costs, then wouldn't that sort of benefit the appellee's argument here?
I'm sorry, it depends on if the plaintiff is alleging that the employee was acting in the scope of his or her employment. Because if they allege,
assuming so,
if they're alleging that, then that's the same as suing in official capacity, which is the same as a suit against the city. And this is why they would get that person out, and then you proceed and see if there is a waiver of immunity alleged properly with the facts against the city, and that also includes allegations of what the employee did. So they've got to show that the employee's actions in scope of employment would constitute or would trigger the waiver of the immunity, and then it might get into the city and it might not. The city might be in the suit and might not be in the suit. I disagree with the characterization of if you're in for all purposes, because the way the TTCA is written, and especially if you look at the more recent cases from the last several years from the Texas Supreme Court interpreting it, they're focusing on it being a very, very tight strict interpretation of what it says. I realize I've run over.
Yes.
So.
Well, and I think the appellee ran over 1 minute, so I was going to give you another 45 seconds if you'd like.
Okay. Well, and I lost my train of thought by pointing out that I ran over. Sorry. Give me a sec. All right. Here's a way that the plaintiff could proceed toward a judgment that would include everything that you might get against a private party. Just sue the employee in his individual capacity, not alleging that he was acting in the scope of employment. Not even setting up any facts that would get him to the city. The city's out of the whole picture completely. It's just one party suing another party, and immunity is not an issue there at all.
Can you point us to any other instance in which immunity is waived for a claim? I know we talked about the different damage levels, but immunity is waived for a claim, but costs weren't, but the court actually found you couldn't get costs. I know we haven't, but in this context, there's no law, but in any context where costs were divorced from everything else in the immunity.
Justice Kelly, that's why I was suggesting at the outset that this might be a case of first impression about, at least about the interpreter's fees. And to your more precise question, I don't have one that says that. The best I have is where the Supreme Court said, look, it's silent as to that about attorney's fees, and that was a tort case. Okay, they were seeking attorney's fees in that man case, whatever. I'm sorry. And so they were seeking attorney fees in the Tort Claims Act case. Said no, you can't get them. It's not mentioned in there. But straight to your question, I don't have a case that says that, and so here we are.
Okay, thank you.
Thank you. Your time is up. We appreciate your argument. And thank you both sides for your argument and your briefing. This case is now submitted and we are adjourned.
All rise.